The Honorable Court of Appeals of Tennessee is in session.
Good afternoon, everyone. We're glad to see you again, each of you. Welcome to the Court of Appeals. On behalf of Judges McGee and McBrayer, we're happy to have you here this afternoon. As you all know, I think you've all probably participated in these videos before. So you know that it goes along just pretty much like arguments in court do. And if we have any glitches, we'll stop and fix them and resume, okay? So don't worry about that. If there are no announcements or questions, Ms. Dempsey, would you please call the case?
Amy Frogge et al. Versus Shawn Joseph et al.
Okay. The appellant's ready?
Yes, Your Honor.
All right.
May it please the court, I am Catherine Kimmel here with my law partner, Charles Cagle, on behalf of Dr. Shawn Joseph. And I would like to reserve 3 minutes of time for a rebuttal for appellants, please. I am here today to present the single most important issue in this appeal, and that is the issue of standing. Appellees have not and cannot establish the standing sufficient to maintain their federal or state claims. Critically, they cannot show that they have suffered an injury in fact that is concrete and particularized and actual or imminent. Appellees have asserted that their fear of future enforcement of the non-disparagement clause constitutes an injury sufficient to confer standing. However, the United States Supreme Court, the Sixth Circuit, and this court have consistent case law and analyses for determining when the fear of a future injury rises to the level of an injury in fact. And in this
when it's a First Amendment case, does that change the necessity for an injury?
I would argue it does not, Your Honor. The appellees have argued that under an overbreadth analysis, they are entitled to a relaxed standard for determining standing. But my reading of the case law is that no overbreadth analysis or prior restraint claim obviates the need for establishing an injury in fact. Specifically under Younger v. Harris, the Supreme Court has held that the existence of a chilling effect alone has never been considered a sufficient basis for prohibiting state action, and that overbreadth or prior restraint claims have never obviated the need for an actual injury to be established. To establish an injury in fact, appellees would need to show that their fear rises to the level of a credible threat of enforcement. And this court recently had the opportunity to apply a four-factor analysis for determining when a credible threat of prosecution exists in the recent case, Tennesseans for Sensible Election Laws v. Slattery. The four-factor test, as articulated by this court, includes a history of past enforcement, any existence of enforcement warnings with specific conduct cited, a defendant's refusal to disavow enforcement, and any attribute making enforcement more likely. In this case, the record shows no history of past enforcement, no existence of enforcement warnings because none have been made. Both appellants have expressly disavowed any intention to enforce the non-disparagement clause against appellees in their individual capacities in pleadings on the record. And the only person able to enforce the agreement against appellees is Dr. Joseph, one single person, not the public at large. There is no attribute making this agreement more likely to be enforced. In short, not a single factor of this credible threat analysis tips in the favor of appellees. And it is my argument that they can only show a fear of enforcement, not an actual injury. This court concluded that case by noting that the mere possibility of prosecution does not amount to a credible threat of prosecution, and the threat must be certainly impending to constitute an injury in fact. Moreover, there is existing and binding case law in the Sixth Circuit that speaks directly to the facts of this case. In Henley v. Cuyahoga County, the Sixth Circuit considered whether a non-disparagement clause executed between a private citizen, a former employee, and a municipal board, a governmental body, violated the private citizen's First Amendment rights. And the court upheld that non-disparagement clause as constitutional, and noted that where the parties engaged in negotiations had bargaining equality and were represented by constitutional counsel, no First Amendment rights were waived. Those facts, that fact pattern is strikingly similar to our case here. And I would ask how it can be that in one corner of the Sixth Circuit, a non-disparagement clause can be held constitutional and enforceable, but in another part of the circuit, it can constitute an injury in fact for appellees. I would argue today that that is inconsistent with existing case law, and appellees can, again, not establish an injury in fact sufficient to maintain standing. Finally, I would like to note that there are no exceptions to establishing constitutional standing. As we discussed earlier, the overbreadth analysis does not provide a relaxed standard for standing. And there are no theories of prudential standing or statutory standing that obviate the need for establishing an injury in fact. Those are analysis or standards that exist as an additional layer to standing on top of the constitutional requirements. The bedrock principle of establishing an injury in fact cannot be dispensed with under state or federal law claims. I would respectfully ask the court to reverse and dismiss the trial court's order on the appellee's inability to establish standing. And I thank the court for its time.
Okay, I see no questions, so thank you very much. I guess it's your turn, Mr. Fox.
Thank you. And that's right. My name is Mr. Fox, Brooke Fox. I represent the Metropolitan Government. And of course, I echo everything Ms. Kimmel just said. She stated it exactly correctly. The plaintiffs haven't alleged anything, any kind of facts that would show any sort of irreducible constitutional minimum here, some type of actual or even an imminent harm. And for those reasons, they don't have their foot in the courthouse door. They haven't met the threshold test to even have a court case. And this came about just in June of this year. There was a California versus Texas case that we cited in our briefs a couple of times from the U.S. Supreme Court. And that was the case about the Affordable Care Act. And there, the plaintiffs, similar to here, pointed at enforcement language that they said was pointed directly at them. And the U.S. Supreme Court said, but look, it's not enforceable. It could never be enforceable against you. Therefore, you don't have an actual or even imminent threat of harm. There's no enforcement action that could legally be taken against you. That's what we have here. I believe all the parties, well, I know all the parties are in agreement. The parties to the contract, the parties to this lawsuit, and also the trial court are all in agreement that as a matter of law, this contract could never be enforced against the plaintiffs. We've discussed that quite a bit in our briefs. Would you
give the 5-cent explanation for that? Just a brief one.
Well, just that as a matter of contract law, they are not parties to this contract. They did not agree to the contract. They did not vote in favor of it. They did not sign it. They're not signatories to it. And there's no way under any Tennessee contract law they could ever be bound by it.
The board is bound. Isn't the board bound by it? And aren't they members of the board? And by a majority vote, the board approved it.
Yeah, but the phrases about individual board members, that just meant individual board members can't speak on behalf of the board and speak in such a way that would violate this contract on behalf of the board. That's all that meant. The board is bound by it. It
doesn't really say that, though.
No, and it's inartfully worded language, sure. But the point being is, no matter how severe the language, just like in the California versus Texas case, no matter how severe it is or pointed at the plaintiffs, you first have to have an injury. Like Ms. Kimmel just said, you have to have an actual or imminent threat of enforcement. Here,
so is this what you meant by when Metro and Dr. Joseph stated that they didn't intend for the agreement to be interpreted as infringing on anyone's free speech rights?
Yeah, absolutely. It was never intended to, and as Ms. Kimmel said, we've disavowed it, and disavowment is a factor to consider. The parties to the contract never intended this to infringe upon their First Amendment free speech rights. Instead, as I said just a moment ago, it was only intended to say, look, individual board members, you can't engage in such speech even on behalf of the board. Okay, that's not to happen. And there's no, if you look at the contract, there's no enforcement mechanism from the government. So this is, our facts here are even more in favor of the appellants. There's no enforcement mechanism even built into this contract. The only thing, if we could call it that, would be a private lawsuit on behalf of a private individual. There's no First Amendment jurisprudence that the plaintiffs have cited with that type of fact situation would give them some harm, some injury in fact. And that's what they have to have. Because there's no governmental enforcement mechanism even in this instrument, and because they don't have an actual, that means that they don't have an actual or even an imminent threat. This case might be different if some of the facts arose, like, or in some of the cases that are discussed in the briefs, where maybe there's a shot across the bow, maybe a governmental agency issued a cease and desist letter, or there was some type of warning being called out, some type of threat of enforcement from some governmental agency. We don't, like I said, we don't have that. There's not even a mechanism in this instrument for that. And so it's important. That's one flaw in the trial court's logic, is the trial court said it's not enforceable. It can never be enforceable against these plaintiffs as a matter of law. And we agree with that. The trial court, though, for some reasons, leapfrogged over the threshold analysis, is that it has to have an injury in fact. The trial court believed that somehow still gave them an injury in fact, but it does not. There's no case law that would support such a notion. Now, see, my time is just about to run out. I just want to conclude by saying, because of that standing issue, the lack of standing, that is a priority issue over all the claims that Mr. Horowitz wants to make on behalf of the plaintiff. Because standing must be dealt with first, that takes priority. For these reasons, like Ms. Kimball said just a moment ago, the plaintiffs have not alleged sufficient facts, any facts at all, that would give them standing, an actual harm or threatened harm whatsoever. And for these reasons, the trial court's decision should be reversed and with instructions on remand to dismiss the case. Thank you very much.
Thank you, Mr. Fox. Mr. Horowitz.
Afternoon, Your Honors. Daniel Horowitz of the Nashville Bar on behalf of the appellees. Your Honors, despite what you've just heard today, it is not an exaggeration to say that this case presents one of the most flagrant and premeditated constitutional violations in recent Tennessee history. During the midst of multiple scandals, defendant Shawn Joseph, Metro's former director of schools, made an illicit agreement with a bare majority of the Metro School Board not to criticize one another. As for the specific terms of those censorship clauses, despite Metro having you believe to the contrary, the agreement itself is clear and unambiguous. The clause that applies to the school board forbids any disparaging or defamatory comments regarding Dr. Joseph and his performance as director of schools. And it defines those terms in a manner that prohibits even truthful statements that ridicule or adversely affect him. The school board censorship provision also states with unmistakable clarity that it shall be effective for the board collectively and, quote, binding upon each board member individually. It also states that defendant Joseph does not waive any right to institute litigation and seek damages against any board member in his or her, quote, individual capacity who violates the terms and conditions of the school board censorship clause. Despite those terms, though, Metro would have you believe that this provision was not intended to bind the plaintiffs. Your Honors, this claim is unbelievable, and I mean that in the literal sense that it is beyond belief. To get there, you would have to ignore the fact that the agreement itself states that it applies not just collectively, but is also separately, and I'm quoting again here, binding upon each board member individually. You would also have to ignore the fact that it speaks to litigation against any board member in his or her individual capacity who violates it. None of these provisions would make any sense if the agreement applied only collectively, and Metro's proposed misreading of the clear terms of this agreement should be rejected as a consequence. Given that the school board censorship clause purported to bind each of the plaintiffs, then the question becomes, did they have standing to challenge it? And the answer to that question is yes, of course they did, on multiple grounds. Let's begin with one of the immediate injuries wrought by the agreement, which is that it purports to strip my clients of their absolute legislative immunity and subject them to damages liability in their individual capacities without their consent for doing their jobs. The plaintiffs moved for summary judgment on that claim below. They also won summary judgment on that claim after both defendants waived opposition to it. Both defendants also failed to appeal that adverse ruling thereafter. Accordingly, both that claim of injury and the merits judgment arising from it are not subject to being disturbed on appeal. As for the other injuries involved in this case, the defendants insist that the plaintiffs were not permitted to seek pre-enforcement review to redress them, but the defendants are wrong for multiple reasons. To begin, the plaintiffs' claims were brought under two separate state statutory causes of action, both of which permit robust pre-enforcement review. The first statute is Tennessee Code Annotated Section 2914-104, which provides, quote, a contract may be construed either before or after there has been a breach thereof. Based on this statute, courts are routinely called upon to declare parties' rights under contracts before they have been breached, which is what the plaintiffs sought here and which serves as one of the Declaratory Judgment Act's principal functions. The second statute is Tennessee Code Annotated Section 13121, which provides in similarly straightforward terms that notwithstanding any law to the contrary, a cause of action shall exist under this chapter for any affected person who seeks declaratory or injunctive relief in any action brought regarding the legality or constitutionality of a governmental action. Affected plaintiffs may seek pre-enforcement review under the statute as well, as this court did in an opinion authored by Judge McGee in 2019. As for pre-enforcement review of the plaintiff's 1983 claims, as this court held some 3 weeks ago, a plaintiff may satisfy the injury element in a pre-enforcement constitutional challenge by alleging an intention to engage in a course of conduct arguably affected with a constitutional interest but prescribed by the statute. I've done that here. Affidavit of Amy Frogge was uncontested, so were the allegations in the plaintiff's complaint. And two, showing the existence of a credible threat of prosecution thereunder. With respect to the second consideration, plaintiffs may also establish the credibility of a threat by pointing to any of several factors, including the existence of a private enforcement mechanism, which is indisputably present here. Metro just argued that to you, that this is a private enforcement mechanism that Joseph, on his own, may opt to exercise.
What about Dr. Joseph's statement that they didn't intend to affect members who were just speaking for themselves and not for the board?
Well,
does that cure the problem and thus take away standing?
Not even close, Your Honor, and let me tell you why. Over the course of this case in the trial court and on appeal, the defendants have taken 4 different and conflicting positions about how the challenge provision should be treated. Down below, Joseph argued that it was a legitimate speech restriction because the defendants were government employees. By contrast, Metro said that this was a legitimate speech restriction because it affects government speech. On appeal, Metro limits its position to the claim that the restriction doesn't apply to the plaintiffs at all. And Joseph, for his part, contends that the challenge speech restriction remains valid because the plaintiffs have some kind of fiduciary duty not to criticize it. They have taken an all of the above approach, basically asking this court to hold whatever is necessary so that they don't lose, but none of these positions are sworn affidavits from Shawn Joseph stating that he unequivocally disavows enforcement of the challenged censorship clause. He has not done that. It's not in the record. At every opportunity to introduce evidence of that fact, they failed to. All we have are statements by attorneys, which, by the way, have been in conflict repeatedly throughout this case. I'd also like to note that plaintiffs can demonstrate a credible threat of enforcement by pointing to threats against specific plaintiffs involved. Here, the threat is ominously integrated into the severance agreement itself. subjecting the plaintiffs, each of them, to individual liability for damages for violating it. The recency of challenged action has also been cited by courts as a basis for finding a credible threat of enforcement, with the theory being that the government does not enact legislation that it intends to be meaningless. Here, the board's resolution ratifying the challenge clause was undisputedly recent. Accordingly, on multiple independent bases, the plaintiffs were entitled to seek pre-enforcement review of their constitutional claims. Your Honor, to answer your question earlier too, of course, the First Amendment claims at issue in this case are subject to different considerations. It's been meticulously or thoroughly briefed. There is an overbreadth challenge in this case. It's not really an issue in this appeal because the defendants waived opposition to it below and then failed to appeal it. Because the issues involved here can seem abstract, I'd also like to step back and try to personalize the outrageousness of what occurred here. The proper analog of this situation to the judiciary would be if tomorrow, while this case was pending in front of you and adjudicating it was part of your job description, your colleagues on the Court of Appeals adopted a rule that forbade any member of this court from publishing anything critical of Shawn Joseph and subjected you to personal liability for damages in your individual capacities if you did. Under such circumstances, you would have three options available. First, you could self-censor and leave the rule unchallenged. I think it's fair to say that that approach would harm both you and your constituents, though, because they have a right to have duly elected representatives do the jobs that they elected them to do without being subjected to unconstitutional restrictions. Second, you could just go ahead and violate the rule. Of course, doing so would immediately expose you to damages liability in your individual capacity and presumably would subject you to a potential ethics inquiry for violating a judicial rule. And third, you could do what courts have appropriately encouraged litigants to do forever, which is come to court before breaking the law, seek judicial review and a declaration of your rights, and then do the job that you were elected to do under the protection of an injunction. That's what the plaintiffs reasonably and sensibly did here, and they were fully entitled to do it. I also want to take a moment to emphasize that these are public servants we are talking about. Nobody gets rich serving on a school board. As a result, asking public servants like the plaintiffs to expose themselves to individual damages liability before they can seek a declaration of their rights is not reasonable and it is not required. Reaching the merits of this action, which neither defendant discussed, they are simple. Multiple merits rulings below were also unappealed, and you can affirm on that ground alone. With respect to the First Amendment rulings, the defendants do contest on appeal, though. Judge McGee's 2019 decision and TSEL versus Bureau of Ethics and Campaign Finance provides the guidepost. Here, the defendants engaged in speech-restricting government action. The content, viewpoint, and speaker-based speech restrictions involved here also trigger heightened constitutional scrutiny. Thus, it was the government's burden to justify them. In response to summary judgment, though, the government did not meet its burden. Indeed, it didn't even attempt to. Did not introduce any evidence at all or attempt to satisfy strict scrutiny in any respect. Not only that, both defendants have admitted that all of the plaintiff's allegations are true by inexplicably failing to file an answer. Under these circumstances, under each and every First Amendment theory presented, Metro failed to meet its burden of proving that the school board censorship clause was constitutional, and the trial court's ruling should be affirmed.
If once you get to looking at what disparaging and defamatory mean, as I read the defamatory definition, a person could be sued for something that was true. Is that how you interpret it?
Absolutely. They specifically defined the term, and they did not include falsity as part of that term.
What about, this, you would be, I assume they would be criticizing Dr. Joseph for whatever he did in his capacity as Metro Schools Director. So would you have to impose the New York Times versus Sullivan standards and include a requirement of malice in there?
I think of course, Your Honor, and you've hit on one of many, many problems with this agreement. By the way, I'd just like to flag the fact that the consideration that Metro extracted in response is highly improper. Government entities, as a matter of law, cannot be defamed, but here you have school board members extracting that as consideration as part of this agreement. The answer is yes. These are matters of extraordinary public importance, all involving public officials. And by the way, they can't. It's not just that they get sued or are subject to damages liability if they criticize defendant Joseph. It's also if they criticize, let me get the exact terminology here, his performance as director of schools, right? That subjects them to individual damages liability too. It's hard to imagine anything of more important local importance than school boards. And under these circumstances, what the defendants did here is highly problematic, clearly unconstitutional, subjects the.
But I mean, to sort of get it more basic here, I mean, if Dr. Joseph brought a claim under the agreement based on truthful criticism that one of your clients made, I mean, isn't the first thing they're going to say is, well, I didn't sign this agreement, nor did I consent to it?
Your Honor, that's one of the things that makes the agreement illegal. That's part of the judgment here. It's that they purported to bind, the board did bind and said that they bound three. I
mean, it says that individually they will not make statements, but are the individual board members aren't listed as parties to this contract?
No, they are not listed as parties. The school board.
I mean, so why doesn't that sort of end the inquiry here? If that suit came, I mean, it seems like to me, it's like, well, I'm sorry, you're suing on a contract I'm not a party to. I mean, suit over.
It is one of many issues that makes the judgment below proper. This agreement, as a matter of law, is illegal. So by the board voting 5-3 that the plaintiffs shall be bound, so this agreement shall be binding upon each board member individually, and that they shall be subject to damages against each of them in their individual capacity, who violates it, yes, it's a problem. That is a basis for affirming the judgment. You cannot lawfully enter an agreement as a school board.
Well, it's more like, you say unlawful, but to me, it sounds like an impossibility. I mean, you're describing a circumstance I don't know how you get to under law.
Well, I guess I don't disagree with you. I would note that the board members are obviously in privity with the board, and to the extent that.
So, I mean, if I serve on a board, a metro board or a city board of some sort, and the board enters into a contract, the party to provide a service for the board, I can be sued individually, you're saying, for failure to pay? Or, I mean, I don't see, you talk about this ominous threat, and I'm going, how ominous is this threat? How real is this threat? If I'm not even a party to the agreement, you say the threat is a part of it. I just don't follow that.
Your Honor, see, my time's up, but I'm happy to answer the question if you'll permit me.
If you don't mind, because I'm struggling with that conceptually. Individuals that aren't in privity, that are subjected to a claim under a contract, I just don't know how that's a real threat. And maybe that's the best way I can put my concern here.
It's twofold, Your Honor. First, this is not just a contract. It is also a legislative resolution by the board that ratified it and breathed this into existence. But secondly, I agree with you. That is one of many things that makes this agreement illegal. The fact that it quotes or purports to bind each board member individually, including the ones who voted against it, all three of them are plaintiffs here. That's the position, Your Honor. It's that it is illegal for that reason and many others.
Any other questions? Okay, seeing none, we have rebuttal time. Will that be you, Ms. Kimmel?
Yes, Your Honor, unless,
Okay.
yes, Your Honor.
Yeah, and Your Honor, I may like to say one quick thing, but Ms. Kimmel, I'm sorry, I'll let you go ahead and speak.
Okay, I'll reserve some time for you, Mr. Fox. I would first like to rebut Mr. Horwitz's assertion that this agreement serves as a restriction on government action or government speech. And there's a simple reason that that is impossible, and that is because individual board members have no authority to speak or act on behalf of the board. And that fact was established in the Fine versus Stewart Tennessee Supreme Court case dating all the way back to 1896. Individual board members to a school board cannot sign contracts on behalf of the board, and they cannot speak for the board. And so this agreement does not represent any restriction on government speech when it comes to the individual appellees in this case. Second, I would like to highlight, Mr. Horowitz.
And yet we have all this language in this agreement that talks about individuals. I mean, why did your client need these protections if none of that can happen?
I would highlight the fact that reservation of rights language and the non-disparagement language was mutual on both parties to the agreement. And so the protections and the liabilities ran both ways. These were not necessarily protections just for my client. It was mutual language in the agreement. And I would like to propose an alternative analogy for this agreement to what Mr. Horowitz, he used an analogy of the legislature attempting to restrict the speech of the judiciary. And I would submit to you that, the true absurdity of this case is that we have government officials claiming that a private citizen has violated their First Amendment rights, when you normally see in a First Amendment case a private individual seeking the protections of the Constitution from government intrusion or overreach. And here we have the government seeking protection from the Constitution itself. I think that is a more accurate analogy, a more accurate characterization of any absurdity in this case. And Mr. Fox, I would like to give you some time if you need it.
Okay, thank you. Just a couple of things is that Mr. Horowitz mentioned a waiver or abandonment on the part of Metro, but because we didn't file an appeal correctly. But once we file a notice of appeal, as this court knows, all prior orders in the case are subject to review once there's a final order, and that's what occurred here. So there's no merit to that argument. Also, the priority issue here, as Ms. Kimmel and I both stated, is the irreducible constitutional minimum of standing, lack of standing here. So that we filed a motion to dismiss early on in the case to secure those arguments, and that's a technical record, page 111 through 115. Standing, all that has been preserved. And then also I want to make the point that this instrument, for whatever, even if there's a private lawsuit, I didn't say there was a private lawsuit, but at best there could be, it's only a reservation of rights. The parties agreed that they wouldn't waive any rights that Dr. Joseph already had. This instrument didn't create new rights for Dr. Joseph. That's all. Thank you.
Well, thank you. Thanks to each of you. You have given us a great deal to think about. And in due course, we will let you know what we think.
Okay. Thank you very much.
I hope each of you has a good rest of the day. Ms. Dempsey, would you please adjourn court?
This honorable court stands adjourned.
Thank you. You may all sign out now.
Thank you, Your Honor.
Thank you. Goodbye.